I'm going to give a little bit of background on the case, even though MGP Anderson already did. And I'm going to leave a little bit of time at the end, hopefully 5 to 10 minutes of time for questions from the audience. So, in 1981, Newsweek hired Lynn Goldsmith to photograph Prince as an up-and-coming artist. Lynn Goldsmith took photographs of Prince at his concert as well as back at her studio. And ultimately, the photograph chosen for the Newsweek article for the Naughty Prince of Rock is not the photograph that is at issue, so she retained copyright for that work. Then, in 1984, Vanity Fair obtained a license from Goldsmith for $400 to use the Prince portrait as an artistic reference for an illustration. Let me just find the page here. Vanity Fair then hired Andy Warhol to create a purple silkscreen portrait of Prince for an article called Purple Fame. In one of the last pages of this magazine, Vanity Fair gives copyright credit to Lynn Goldsmith as the source photograph. Sometime after, Andy Warhol created about 15 additional works, which have come to be known as the Prince series. During that time as well, Goldsmith also licensed her Prince portrait to other magazines during this time on the cover as well as in between the pages. Flash forward to 2016, Prince passes, and Condé Nast, which is Vanity Fair's parent company, wants to reuse the 1984 purple portrait for the cover of their special commemorative magazine. However, after reaching out and learning more about the Prince series, they get a license from the Andy Warhol Foundation for orange prints rather than reuse the 1984 Purple Fame prints. Now, at this time, Goldsmith contacted the Andy Warhol Foundation in belief of copyright infringement. The Andy Warhol Foundation then sued Goldsmith for declaratory judgment of non-infringement and in the alternative fair use. At that time, Goldsmith counterclaimed for infringement for all 16 works in the Prince series, and ultimately the district court considered the 4 fair use factors in 17 U.S.C. Section 107 and granted the Andy Warhol Foundation summary judgment on its defense of fair use. So they sided with the Warhol Foundation. On appeal, the Second Circuit reversed, finding that all 4 fair use factors favored Lynn Goldsmith instead, so they came out the exact opposite. Then on appeal to the Supreme Court, they granted review, but this time for a narrower set of questions, now focusing on whether the first fair use factor, which is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, weighed in favor of the Andy Warhol Foundation's recent commercial licensing to Condé Nast or not. Thank you. Now I'm going to begin our conversation here. Had to rework my questions a bit. Professor Menell, do you want to first discuss how you became involved with the Andy Warhol case? And it involves a fun Ninth Circuit case as well as a final exam hypo. And then go into a bit of the history of the case law that is at issue here from around the 1976 Act.
Well, thank you, Samantha. Thank you, Delia. And it's a real honor to be part of this conversation. And partly because I am going to speak favorably about the decision, I'm a bit aware that this is perhaps not the most sympathetic place to be talking about that. And I want to say I very much appreciated the prior presentation. But I also, just by way of background, want to say that we each live in our bubbles. We're each influenced by various sources. We have different training. And part of my training is that I'm trying to decipher how our laws work. And for me, that involves a lot of research and training, perhaps of the type that a model would do. I spend a lot of time poring over the history of copyright law, in particular, the legislative histories, and I can't say fair use was my primary research focus. My work began 40 years ago as a software person in a law school environment that didn't think technology mattered. How the world has changed. And I wrote early articles about software protection and was generally very skeptical of software protection through copyright. And eventually the courts came down that path. And then after starting the Center for Law and Technology at Berkeley, students approached me about being interested in entertainment and other parts of copyright. None of my colleagues were that interested, so I took up teaching about entertainment, and the internet happened, Napster, and a lot of the other challenges that we've had. And I would say that the AI revolution that we're experiencing now is on par or exceeding anything we've seen before, and we've seen a digital revolution and an internet revolution. So there's no doubt in my mind that the presentation you heard earlier and what's going on at OpenAI and other companies is going to be extremely important and disruptive. And disruption, for me, is not necessarily a bad thing, but it's a thing that requires our attention. Our laws are set by Congress and lawmakers, and so part of what I would say motivates my interest in work is what I would call rule of law, that we want to have laws that are understandable to the public, that are somewhat neutral as possible in their interpretation. And so if we were to draw a parallel to the Prince photograph and the Prince career, there is this direct parallel to the 1970s, early 1980s, when the photograph in question was taken, and how we were, for the first time in American history, incorporating fair use into the copyright statute. The 1976 Act did that. That statute was in gestation about 20 years, and there are about 14 volumes of legislative history accompanying that. And so part of my work is I read through that. It's a little dull, but it's always revealing. And as I've dealt with technology challenges over my career, I've often found very interesting insights, partly because the legislative history, especially of the 76 Act, less so of some of the later acts, was very transparent. The meetings were held in public sessions, everything was transcribed, and you can go back and really find a lot of very interesting conversations about the future and what might happen in 50 years. And we are now 50 years out. And in a 1965 report, legislators talked, or I shouldn't say legislators, the drafters and the people who were involved in the drafting process talked specifically about trying to deal with unforeseen technological changes. So we're living through those eras. Now, the Warhol case is not a technology case. It's a straight up art case. But because it is a watershed case, and the Supreme Court only does one of these every 30 or so years, it will have tremendous importance. And one can even see in rereading, as I've been doing, the Supreme Court's decision, it will feed directly into some of the litigation that is now bubbling up. So let's go back in the time tunnel. And I loved our first presentation because what were the cultural, artistic influences in my life, and as my students here, it was Pete Townsend and the Who, and The Greatest Scream in Rock and Roll History, which continues to reverberate in my ears, and just the kind of thinking that Pete Townsend was thinking about in the early 70s about who's the boss and how society is going to deal with these power struggles. Won't get fooled again. The other major influence was Gene Roddenberry and Star Trek, and trying to use this television format to help people to imagine a world beyond the kind of racism that existed in that time period. And so for me, I see why museums and art are so important, and how do we support artists and future artists. And I guess one perspective we didn't quite hear, maybe Jim Block, who's our Berkeley photographer, could present it, is how he makes a living. And I see in Justice Sotomayor's opinion this effort to talk about both Lynn Goldsmith and Andy Warhol, and to try to strip away fame, and to speak very much about how art and artists are an unpredictable process. One of the most important artists from my youth was Bruce Springsteen. And when you read his biography and autobiography, what you see is that he struggled mightily, almost didn't make it. But without a copyright system, you don't get someone like him. And we have to balance between those original creators and those who would build on top. We have things like a cover license in copyright, which allows others to cover. And I constantly appreciate, for example, one of my favorite songs by Bruce Springsteen. He wrote with Patti Smith, but they both recorded it, and now others have recorded This Is Because the Night. And there's a tremendous amount of, I would say, borrowing that goes on, and I wouldn't deny that. And I think the real challenge for copyright is trying to achieve that balance. And the way Congress did it was to create a right to prepare derivative works. And that's, a strong part of the 1976 Copyright Act, and a fair use provision. It defined derivative works to include works that are recast, adapted, or transformed. So it has the word transform right in there. So how do we get to this battle right now, battle royale over transformativeness? Well, after the 76 Act, it didn't take long before these cases rose to the Supreme Court. We get the Harper and Row case involving a presidential memoir and a relatively small amount of text, about 300 words that were taken, but they were the heart of the memoir, and the Supreme Court ruled, I think, on the author side, the original author side, pretty firmly, and there's a lot of language in the case that ends up getting seen as being very expansive. But at the same time period, you get the Sony case, the Sony Betamax case, more involved with technology, but the question was, can you copy the entirety of Hollywood creations for later viewing, time shifting? And the Supreme Court, even though this is clearly a commercial use, ends up saying, no, that's okay. There's a lot more to the details, but it was a very complicated case. And I'll just say it wasn't an easy case. People look back on it now and say, oh yeah, that's the Sony case. It was one of the only cases in US history in which the Supreme Court didn't resolve the case in the term it heard it. In fact, Justice Blackmun was writing the majority opinion. Justice O'Connor, who was newly appointed to the court, was part of the majority, and she defected over a series of months. And one of my more interesting research projects was after Justice Marshall's and Justice Blackmun papers became available, to get all the correspondence that went back and forth among the justices. And what you see is this evolving story that leads to the Supreme Court rehearing the case the following term on the same briefs and coming out 5-4 in the opposite direction. So fair use has always been a controversial issue. And the lower courts were struggling even more. And you have a series of cases in the Second Circuit with Judge Laval featuring heavily, in which he's dealing with some interesting battles. One of them involved a biography of J.D. Salinger, which was written based on letters that J.D. Salinger had written to others, but were in private library repositories. And Ian Hamilton, a British biographer of note, figured how are we going to tell J.D. Salinger's story? He comes up with this idea of going to the libraries and pulling those letters, and then using those letters to retell the story. I'll say completely randomly, happened to be clerking for the judge who was reviewing that decision, John Newman in the Second Circuit. And Judge Newman struggles very much with that case, but what he saw ultimately was that Judge Laval had not counted the paraphrases in doing the analysis of the case, and it was a close case, but ultimately the Second Circuit ruled that it was not fair use, and I met Judge LaValle years later, and we had an interesting talk about that. But I'll say that Judge LaValle later came to see that he had perhaps miscounted or miscalculated, but you just see that fair use is a very complicated doctrine, and for an artist, I think it would be very hard to know where those lines are drawn. I will note that it's rare, though, that these cases arise. It's rare that there is enforcement, there is what we call a lot of tolerated use, and I think there are positive signs in this decision, both about how you would apply the case to some of the work you showed, but also in the Second Circuit's opinion, there's a lot of discussion at the end saying, well, we haven't dealt with remedy here, and the remedy might just be a fairly reasonable royalty, and that might be a way to balance the scales in these kinds of cases. But okay, so we get to the Second Circuit battles. There were actually 3 cases in which Judge LaValle, was, as he said, at the cutting edge of the law, but in the position of the salami being sliced. And he ended up writing a very thoughtful article where he tried to go to the core of what fair use is about. And this is where this transformative notion comes up. And I don't know whether he was that aware of the use of transform in the definition of derivative work. It's not apparent from his article. Probably not the best choice of terminology, just because we've been struggling with that ever since. But I think the ideas behind transformation are very vital and important. He traces it back to Folsom v. March, the original Justice Story case, where this doctrine, fair use, flows from. The Campbell case was the first opportunity for the Supreme Court to apply this in a type of remix art case, a case in which Luther Campbell and Two Live Crew were using Roy Orbison's Oh Pretty Women for the song Pretty Woman, which was a rap commentary. At least the deposition of Luther Campbell seemed to indicate that he was aware of a parodic and critical element, and he viewed Roy Orbison's song, which I always just thought was a song about a pretty woman, but it's a song about a streetwalker. And he said, Luther Campbell in his deposition said, this is a romanticization of streetwalking. It's a dirty business. And this is the same time, you might remember, some of you would be of this age, we have Richard Gere and Julia Roberts in the movie featuring the song. And so I think there was a lot more cultural going on there. And the Supreme Court didn't rule that this was fair use. What they ruled was that this transformative notion needs to get brought in, that there's a balance. And in fact, the Campbell decision is one of the most sophisticated decisions in all of copyright jurisprudence. It goes very deeply into balances, but over the decade following that decision, and the case was remanded and settled, so we don't know whether it was deemed, whether there was a fair use or not. There was probably money that changed hands, and we got both songs out into the world. But over the next decade, we see this kind of this simplification of the Campbell case down to really a paraphrase from Judge LaValle's original article. And the paraphrase really just focuses on, is there a different purpose, new meaning, or new message? And that's where we get the Blanche v. Coons, the Cariou case, and the Bill Graham Archives case, all appropriation art cases. And those cases seem to say you can copy things pretty much verbatim. If there's a different use or a different meaning, that's good enough. And those cases, I think, is what leads to the Warhol case now, is that it created this new bucket where you could essentially copy the entirety of a work or a portion of a work, and it be deemed as a transformation. Transformation is no longer limited to a physical change. And we start to see some rumblings in other courts, the Seventh Circuit, Judge Easterbrook's opinion in the Scotty Nation case, and then the case that brought me into doing this, which was the Dr. Seuss Enterprises versus Comic Mix. So this is the case that I thought would go to the Supreme Court because it was very colorful. It involved Star Trek, and it involved some artists, entrepreneurs, who had the idea of taking one of the most popular and successful books in all of American literary art, Oh, the Places You'll Go. And it's especially popular. I didn't know this until I got involved with the case, because it is the most common graduation gift every May. It sells out of book and card stores. And so these guys got this idea that they would develop a remix of that with Star Trek, the original series, of course, for All the Places You'll Boldly Go. And a judge in Southern California heard the case. That's where Dr. Seuss is located. She wrote a statement of facts. In the statement of facts, she explains everything that happened, a lot of email correspondence among the parties. And I'll say it was a very mercenary and not very, it was not focused on criticism or commentary. They said, we'll sell a lot of coffee mugs, we'll do a lot of this and that. And so I just took the front part of her opinion, a judge in Southern District of California, and I asked my students as part of their final exam to write the analysis. Is it fair use or not? And to my surprise, in a class of over 120 students, the overwhelming majority said it wasn't fair use, which was exactly the opposite of what the judge in the case. And it just highlighted just how subjective fair use had become. That, she apparently liked, the judge apparently liked the work, but when you tried to work through the facts and apply the 4 factors, I think it did point in the other direction. I reached out to the lawyer in the case, just called her up randomly, and I said, out of the blue, and said I'd be interested in talking to you more about the case. I told her about the exam result, and she said, oh, let me send you the full book, because the only images available were part of a Kickstarter campaign that the defendants had done. And when I saw that, it was really slavish reproduction. And so, I said, I think I'm going to write a brief in this case. And the brief focused on reconciling 106.2, the right to prepare derivative works, and Section 107. I'll say Judge McEwen was somewhat amused by the brief, because one of the lines in the brief was something to the effect that if you can get away with all the places you'll boldly go, then anyone could write all the places you'll Pokemon go, or all the places you'll yada, yada, yada. And I came up with 3 or 4 other titles, and I said, I don't think that's what Congress had in mind. And in our brief, we went through the legislative history and said, no, these are not the kinds of things that Congress was trying to say would be fair use. To the contrary. And the Ninth Circuit decision, I'll say, somewhat sidestepped the core question, but the analysis in our brief fit perfectly once the Warhol case arose, because we had done some of this research, and by we, I said Professor Shambhal Ganesh, who's my primary co-author. David Nimmer joined us on the Dr. Seuss brief. Professor Jane Ginsburg joined us on this brief. And we tried to really reconcile what was a way to have both a right to prepare derivative works and a robust fair use provision. And it led us into these balances that are really at the core of the Campbell case. And I'll just say the Campbell case should be reread by everyone, because it was not a one-sided everything's fair use if it has new meaning or message. It was, you have to be very careful of the balances within each of the factors. Now, the fact that this case only deals, the Warhol case only deals with factor 1 was by the choice of the Warhol Foundation. They conceded the other 3 factors. And they said, we'll go with the Second Circuit's analysis because we think we're going to win on this one, and that's because we think that this paraphrase analysis, which the district judge did, is the correct analysis. Well, it didn't happen that way. I think Justice Sotomayor wrote a very thoughtful opinion in which she goes through methodically all of these issues, and she tries to provide courts with a lens for thinking about these questions. She wasn't thinking about ChatGPT. She wasn't thinking about a variety of other cases that are going to be affected. But just as Campbell provided the watershed case, Warhol will do that, I feel. And, as I'm revising my case books this week, I'll just say, we're going to be getting rid of a lot of what we had in there and this will become the framing for how this is put forward.
Thank you for giving us that run through and your background to your involvement in the case. We all have homework now to go back and read Campbell. That includes the artists in the room. So the Warhol opinion, the main takeaway here was that the first factor really emphasizes the specific use of the secondary work. Can you talk about how that rebalances and affects Campbell a bit, and whether or not you think that struck the right balance and answers a question relating to whether we can tell the difference between a transformative derivative work and one that is infringing?
Okay, so I'm going to separate that into two questions. One of the real insights of Justice Sotomayor's opinion, and I'll say it's not something that was in our brief, although many of the things in our brief do find resonance in the opinion, but this focus on the unit of analysis, the notion that the fair use doctrine is about use, whereas infringement analysis is usually about the work itself. And so I do think that that will cause everyone to be rethinking how they provide opinions in this area. And the reason I think the use analysis is so important, and I think will allow museums and perhaps other entities to be less worried, is because the use goes to how we're going to balance the transformative versus commercial or other character aspects. And so if what you're doing is projecting an image on a screen, a public performance, a public display in a nonprofit setting, that will affect the analysis. And the Supreme Court was saying, we're not even judging the orange prints. Now, some people might say, oh, well, maybe it's not an infringement. I think there's enough indication that they think that that at least the majority opinion didn't think that that was fair use, but they didn't have to say it. The concurring opinion by Justice Gorsuch does say we're not adjusting that question. But I think that, Warhol was an incredibly important figure in art, but to say that orange prints was transformative, I think perhaps goes beyond credulity. I mean, it's not a very different image. And I'm not trying to be an art critic here. I'm just saying it's not of the character of the early Warhol that really broke through. It became kind of a fairly stable, a fairly repeatable type of work that characterized his later career. I was struck when the New York Times published a piece by a Stanford art historian on Monday about the case, talking about how later in life you could pay $25,000 and have a Warhol done of yourself, and for an extra $15,000 you can get another panel. And I just found that a little sad because it just seemed like a business, and that's not how I would like to think about the great artist. But Warhol played with that idea. But I think what you see in the Justice Sotomayor opinion is we're not going to get into these what you might call high art or literary criticism perspectives. We're going to try to look at these cases through the lens of the copyright statute, which treats all of the artists on an equal footing, that there's no sort of Warhol exception here. And so I just think that the purpose is going to play a very important issue. The court limited an earlier case, which many copyright professors or practitioners are familiar with, what's called the Bleistein case. And this was a case where Justice Oliver Wendell Holmes says, we're not going to be judges of art. We're not trained to do that. And I think that's still valid law, but it's been limited in the following sense. The Sotomayor decision is saying, well, we can judge purpose. We're not going to allow that to go to art critics any more than we're going to allow it to go to anyone else who would judge art. We're going to carve that out. And that's something that our brief had talked about, how it's possible for judges to make that kind of determination without getting into judging art, that purpose is something that is within their ability. Now, once you get into the question of whether something is transformative for purposes of factor one, you have to do a balance. And what the court repeatedly says, it's a through line throughout the case. It also shows up in the concurring opinion, where Justice Gorsuch says that we usually don't interpret cases, interpret statutes to be at war with themselves. And to have a right to prepare derivative works and a transformative exception would be at war with itself. So by transformative in section 107(1), we mean something more. Now, they don't tell you how much more, and they say it's going to be very contextual, and some people say, well, that makes the law very uncertain. Well, the law has always been uncertain. I think it makes it more certain than it was, because now we're going to be asking, well, is it a commercial use? What had happened with commerciality is a somewhat sort of odd detour, that in the Sony case, the Supreme Court dropped this line that if a work is commercial, then it is presumptively not fair use. And that was not justified. And the Campbell case correctly said that there is no presumption that because something is commercial, it's not fair use. But courts took that too far in the other direction. They treated commerciality as irrelevant. And what we see here is that commerciality or nonprofit education, these things are now going to be part of the balance. And so it gives me a little more comfort, because as a nonprofit educator, I don't have to worry quite as much, because I do think the court would treat my uses and many museum activities and many other activities as weighing favorably towards fair use. But in the world of commerciality, not so much. And that's why it was so interesting to hear the earlier panel talk about commercial activity and also licensing. So one of the really interesting parts of this case is that there had been a license, and that, I think, did color the facts and make it seem a little unfair that, well, you paid a license fee and you gave attribution. That's another thing that comes into the case, is there's a moral rights dimension, that Lynn Goldsmith didn't get any attribution credit the second time she was used, and in fact, that image is as much similar to her earlier one as before. So what you see here is, I think, companies, and in the AI space, we're reading more and more about this, there's going to be some kind of process whereby companies develop their training data. And I think there's a lot of thought that has to go into how you do that, because that's going to come back, and the fact that our guest earlier is speaking publicly, there's going to be a lot of material out in the public about how these LLMs are created. And so, I wouldn't want to predict how this next wave of litigation goes on. I think it will have very different character to what we're seeing in the Warhol case, but we're seeing some contours, and the licensing aspect is going to be important. Now, I would say licensing has been considered it has been denigrated in a lot of art contexts, that many people think that this is an unfair burden to place on artists or on creators. But I think there's a flip side of that, and that's that there's a fairness element in sharing the wealth associated with appropriation art. In fact, Professor Meyer's op-ed piece in the New York Times saying that the Supreme Court got the Warhol case wrong, I read through the reader comments, and the reader comments are ranked under reader picks by frequency of recommends. And you have to go down about 30 comments before you get anyone who agrees with Professor Meyer. That the overwhelming view of people who read that piece, and this is the New York Times, which is already in an elite world, seemed to be that there's a lot of fairness and a lot of balance in the Supreme Court's decision. And you read down 30 or so comments, and the one comment that first comes up is, oh, the Supreme Court gets everything wrong. Well, how can you say that about this case? You've got 2 liberal justices in the majority. You've got 5 conservatives in the majority. It's really not it's not a politicized case. This is a case that I think is getting to sort of core notions of fairness. And I do feel that the case has some of those dimensions. And Justice Sotomayor goes out of her way to say, we're dealing with 2 artists. And that, I think, is one of the most important messages of the case. And it's important for the art world to hear that we're trying to support, I mean, if we were to go to the Rock and Roll Hall of Fame for this event, rather than the San Francisco Museum of Modern Art, I think we might have a very different view of Lynn Goldsmith vis-a-vis Andy Warhol.
Thank you for touching on all of that. You've discussed Justice Sotomayor's opinion in good detail. Can you touch on Justice Kagan's dissent and specifically the concern that she has that this will, affect creativity, have a chilling effect on creativity?
Yeah, no, and I think we heard that from our prior speaker, and I think that these are very real issues, but they're also empirical issues. And I think that among photographers, we might find that this will have a positive effect, and their work is an important source material for artists. And we may see different licensing organizations emerge to help support, I'll say, commerce and the sharing of value. So I can't say I know the answer to that. I did have the opportunity to be classmates, law review member, and friends with Justice Kagan, and also with appropriation art. In fact, Professor Meyer's op-ed piece in the New York Times saying that the Supreme Court got the Warhol case wrong reflects, I think, a view that you'll see, especially in academia, that might be associated with the idea that copyright is overly strict and suffocating. But I don't know that view is the real view as reflected in the world as we know it. It's been a popular view. I'll remember when Larry Lessig's book Remix came out, and it was a very popular view of many younger people that we ought to be able to freely take other works and remake them. And we've lived through a tremendous disruption over those kinds of questions. Should copyright be enforceable on the internet? And these kinds of questions have been resolved, not often in the way that the people who I associate with copyleft would have preferred. But the world didn't end. The Grokster case, for example, I think produced the models of Spotify and Netflix and Amazon Prime that many of us are very happy to have in our lives. And I think this decision will certainly change practices. I think there's going to be different types of diligence that goes on, but I wouldn't want to predict the end of creativity. And also just note that Justice Kagan has a very sharp wit and sense of humor, and I would say she can be snarky, and her opinion reeks of that. And I think that was very uncomfortable for Justice Sotomayor. Justice Sotomayor was trying to work through complex balances and details, and I think it was frustrating, and you see this in the back and forth in the opinions. And I think that's unfortunate because, I would hope that they get along, and I would also hope that there would be a little more that they could agree on. But I don't think we will see a collapse. I don't think we're going to even see that much change. It's rare that parties can bring these kinds of cases and will pursue these cases. I think the big risk that we have in the copyright world, and I know it's a big risk for an open AI company, is we have something called statutory damages. And statutory damages got elevated during this digital revolution to a level that I think creates all kinds of unfortunate risks and and challenges for companies trying to get started in these spaces. And the Supreme Court interpreted the statutory damage provision to say that this is something that goes to a jury, which adds other risk and uncertainty. So I hope, and I've been advocating this for a long time, that we could get Congress to try to deal with some of those adverse aspects of copyright. But I don't really see Congress really taking up a change in the fair use provision as a result of this decision.
You've mentioned this a little bit already, but you're talking about the effective licensing in this case and just in general. In previous conversations we've had, you mentioned to me about how you thought the licensing and the decline of a license in the Bill Graham case was important. Do you think maybe moving forward, now that the commerciality factor is more important, that if somebody is denied a license, what effect that might have?
Yeah, so a little background. This is a San Francisco case. Bill Graham Archives, the impresario, ran the Grateful Dead's career, and they owned all the art. And when an author wanted to do an anthology, the Grateful Dead reached out to the archives and said, "We'd like to use, ticket stubs and posters in this anthology way. It won't substitute for what you're doing. We're willing to pay a license fee." And the archives was not willing to extend a license, and they went ahead with the book. So this is in 2006. This is an important year in the intellectual property world because in a parallel litigation that year, the Supreme Court decided the eBay case. The eBay case really changed the whole remedial structure surrounding intellectual property in making it much less likely that you'll get injunctive relief than had been previously the case. And when I read the Bill Graham Archives case, which was decided in that same year, I feel that the Second Circuit is communicating that, why didn't you just give them the license? They're being reasonable with you. But because you didn't do it, we'll call it fair use. We'll say it's transformative, even though you took the entirety of the works. And I think in today's world, and this is what Judge Lynch's decision in the Warhol case talks about, saying, well, we might not say it's fair use, but we might not give you an injunction, and we might not even give you much of a remedy. And I think that would be a fairer solution in a lot of these cases. And the only risk, which I mentioned earlier, is that you could get into a statutory damage kind of situation. But if it's a single work, it's not going to probably lead to the very high levels of statutory damages. The bigger risks are for ingestion of thousands or millions of works. And that's where I think we ought to focus reform efforts.
Thank you, Professor Menell. I believe we are at time. It's been a great conversation. Thank you, Delia, for inviting us, and SF MoMA for hosting.